All right, we're going to go ahead and get started. I want to first off thank everybody for joining us this evening. We know that we must be coming out of a once-in-a-century cold snap and still be in the midst of a global pandemic when people are joining us to talk property taxes on a Thursday night. So thank you all very, very much for making the time and effort to join us. I'm always surprised at these things when we do them in person or online of one sort or another to talk about policy, is how encouraging it is for KPI and for our supporters and our staff to know how many people really do care about these issues and they're willing to take time out of their lives. And kids, here at our home, it's the witching hour, is getting ready for bed. So I apologize if anybody hears wailing and gnashing of teeth in the background. I don't know if that's my wife or our children, but one way or the other, we very much appreciate you making the time. My name is James Franco. I'm the president of Kansas Policy Institute, and we are Kansas's only think tank dedicated to limited government and letting you have the more freedom to run your life, raise your family, run your business the way you see fit. We think that society's problems are best solved when government steps back and gives organizations, individuals, families, civil society the opportunity to step forward and address those challenges that our country, and for us at KPI, our state faces. Tonight, we're here to talk property taxes. And like I said, my name is James. I'm the president of KPI. We have Dave Trabert, the CEO of KPI. Dave, wave. All right, that's Dave, everybody. And then we also have Linda Terrill, who's joining us. She has her law degree from Washburn and a master's in taxation law from UMKC. I'll do a little bit more of an introduction as well, but we're going to go through some of what's going on in Topeka related to property taxes, as well as the really meat and potatoes of this evening is to talk about the property tax appeals process. And we could think of nobody better to lead us through that discussion than Linda. So property taxes, always in the news. We're getting all of, or many of us around the state, if we haven't gotten it already, are getting our valuations in the mail, or will be in the next couple of weeks, which kind of kicks off this process. But every year, the Kansas legislature meets from roughly January through May, takes off April. And we are right now in the thick of that legislative session. And we're running up against what's called turnaround, which is kind of the first real parliamentary deadline in the legislature. So Dave Trabert, the CEO of Kansas Policy Institute, is going to run through some of those goings on in Topeka as it relates specifically to property tax. We're not going to be pulling folks in and out of the discussion with video feeds or audio feeds or what have you, but it should be right over here in your screen are the opportunity to chat or ask questions. You know, there's one of those little thought bubbles from the old Charlie Brown cartoons that's down there for the chat, and there's a Q&A button as well. So we will have a time for Q&A as we get going, and we're going to kick it off right now with Dave talking about what's going on in Topeka. So Dave, take us away.
All right, thanks, James. I think I got myself unmuted there. Just to give you a little bit of background on the property tax reforms that are going on, this really started in 2019 when we were part of a broad coalition that took a deep dive into a number of property tax issues. It included legislators, local officials, property owners, policy experts, and all kinds. We spent literally months examining about 30 different kind of property tax complaints. Then we ranked them kind of from most to least objectionable. They were all objectionable, but at least from the taxpayer standpoint. And then we settled on about a dozen to really push hard on legislative remedies. It's one of the challenges you face in trying to move policy is you have to be patient a little bit, and really you try to get too much done, you won't get anything done. Senate Bill 13 is the big issue. It's the most well-known and may have the most impact of all the property tax reform we're working on. It's been called the Truth and Taxation Act. Basically, it requires local officials to be honest about the entire tax increase they impose. No more saying we're holding the line and pretending there's not a property tax increase when you keep writing larger and larger checks. That bill passed the House with a huge 34-1 margin, and it's gone over to the House Tax Committee. That committee recommended the bill for passage with a slightly modified version, a couple of amendments that look okay overall. We'll be able to work on that. The full House should be taking that bill up pretty soon. One of the valuation issues that we identified that's included in Senate Bill 13 is prohibiting valuation increases that result from routine maintenance or replacement. That was one of the really big valuation issues. There's several other bills moving through. Some of them are touching on issues you might not be aware of. Like there's ways that we're trying to rein in some rogue county appraisers that have been pushing what's called a dark store theory. They're trying to change the valuation method in a way that is the Kansas Board of Tax Appeals has said is contrary to state law. So there's a number of things addressing that. There's some technical things that make it easier for property owners to get information from BOTA on an appeal, when they can get it, and so forth. Those are the big issues on property tax. We're pretty confident that we're going to be able to get Senate Bill 13 through the House. It'll have to work out some of the differences with the Senate. And we're hopeful that Governor Kelly won't veto it this time. Cities and counties certainly want it vetoed. They're adamantly opposed to having to just basically be honest with you. And that's unfortunate, but we're really confident about that. And I'm going to turn it back to James unless anybody has any questions.
Right. So if you do have questions, remember just right over here should be in your bottom right-hand corner. There's a chat button. And then if you don't see it, there's an ellipsis, the three little dots, where you should be able to get to a Q&A as well. So I'll stall here for a second if anybody has questions for Dave. You said it passed the Senate 34-1, came to the House Tax Committee, was heard. Their past committee slightly amended, and now we're going to the House floor at some point. And then you said last year Laura Kelly vetoed a version of this bill. Why wasn't there an attempt to override that in the 2020 session?
Oh, that's a great question. The bill passed on what was the legal last day of the session, called sine die. And so because they weren't able to come back, they didn't get a chance to override the veto. We're confident it would have been overridden because it passed both chambers with veto-proof majorities. You need to have 2/3 of the House and 2/3 of the Senate to override a gubernatorial veto. So we're hopeful that, that's one of the reasons they wanted to open the session with this bill. House and Senate leadership are very committed to getting this bill passed and getting it to the governor's desk in plenty of time to override a veto if she does this time.
Okay, Dave is going to stay with us, but Linda is no wallflower, and we want to bring her into the discussion here as well to talk, like I said, about the real meat and potatoes of the evening, which is about property tax appeals. Like I said briefly at the introduction, Linda Terrill has her law degree from Washburn, and a master's in tax law from UMKC. She's the former general counsel of the Board of Tax Appeals. She practices currently in private practice, representing property owners in their appeals and probably a variety of other stuff as well in Overland Park. She's the president of American Property Tax Counsel, and has litigated several cases at the Kansas appellate court level. So Linda, thank you very much for joining us. Thank you for making the time. And like I said at the outset, just briefly, there's 3 different ways, if I remember correctly, Linda, that taxpayers, property owners can appeal their property taxes. There's when they get their valuation notice. They can do it when they pay, a portion of their property taxes in December, but they would do so under protest. And then when the second half of that property tax payment is due, they could pay it, or protest it again when that next payment is due. What we're going to talk about tonight, or at least where we're going to kick off the discussion, is where we are now, which is when you get the valuation notice. If you haven't gotten it already, stay glued to your mailbox. You'll get it shortly from your county. And that's what we're going to focus on tonight. So Linda, again, thank you very much for joining us. So take us away. What happens if we don't feel that the valuation is correct? What do we do?
Okay, well, first, let me thank you for inviting me to speak. And I'll warn you all, I love talking about property taxes. I know maybe the rest of you do not, but it's my favorite subject matter. So as we just said, you have 3 chances, which is wonderful. Many states don't give taxpayers that opportunity. But remember, you just get to pick one. Stick with it, because if you start one and you stop, you can't avail yourself of a future appeal. So what you're going to get here quickly is your valuation notice for 2021. If you have a commercial property in Johnson County, they already mailed them out. That was February 15th. And your appeal time has already started to run. Most counties, though, there's a little variation, but most counties will send their valuation notices out around March 1st. And you have 30 days to decide to appeal. So let's think about this. You get your valuation notice, and it'll say it'll give you your last year's information. So you'll be able to see if it went up or down. And then it'll give you a value, what they call an appraised value, and then assessed. Assessed, if it's commercial, is just 25% of appraised. So focus on the appraised value. You need to look at that number, and then you need to ask yourself some questions. I know that I've heard people say, well, the taxpayers just want one value when they sell the property and another value when they're arguing about the value of your taxes. And the answer to that is, if you have commercial property that is investment property, in other words, leased out, yes, that's exactly what you're doing, because we don't tax the investment value. We tax what we call fee simple, and we'll talk about that a little bit later. It's a dry appraisal term, and it certainly is, but boiled down to its simplest terms, you ask yourself this question. We value property on January 1 as if it was sold on January 1. So in your head, you imagine that you're going to sell your property on the 1st of January. And you have to do that. You make your valuation assumption that the current owner or the tenants are going to vacate the property upon the sale. And what that does is it takes all the lease information, all the intangible business value out of the equation. And now we're just looking at the value of the land and the improvements. If you value the property as if it is already leased, and you think about what would I sell it for, then really what you're selling are 3 things: land, building, and the right to receive income for the period of time that the leases are in place. So let's focus on, just like they would value your house, on the assumption that you're going to move out and the new person is going to move in, and we eliminate that intangible value. So if you look at that number and you conclude that number is too high. And from what I've seen so far across the United States, there's a sense that maybe multifamily housing is tenuous. Industrial properties seem to be holding their value. Office buildings are really questionable. And then the hospitality industry has been obliterated. As some people have said, as much as 30 to 50% of the value for restaurants, hotels, any kind of entertainment facility, a casino, you name it. So you need to look at your 2021 number, thinking about, well, my industry might not have been impacted, but if I own a hotel, you were impacted, and you know you were. So, and then let's think about it too in terms of 2020. On January 1, we didn't know we were going to have a pandemic. So that was not considered in your 2020 value, but 2021, we're right in it. And so you need to be prepared to show your county appraiser how your value has changed, how your business has changed, how your tenants have changed, et cetera, from one year to the next. And I think the counties will appreciate it because they're searching for information too about exactly what kinds of properties were affected and to how much. So let's, no matter which of the appeal routes you take, you always start at the county. So if you get your valuation notice and you look at it and you conclude this is wrong, or you think it's wrong, you can appeal. You have 30 days from the date. And if you didn't get one, call your county, because some counties have decided that if they didn't make a change in your valuation, they don't have to send you your annual notice. Well, that's not particularly helpful and I'm not even sure it's lawful, but that's what they do. So if you don't get
right, and Linda, just to be clear here, what we're talking about is you should contact your county. It's not the city, it's not the state.
correct.
Is there a specific office in the county that I'm going to reach out to?
You would call the county appraiser's office.
County appraiser's office, okay.
And you tell them, you'll probably say, I have a commercial property. They'll connect you to a commercial. Most of them have websites. Some of them are very clunky. Some of them are pretty darn good. So you can also go to the county appraiser's office and look your property up. And it'll tell you what the value was before and what the value is now. The reason I don't like the fact that if some counties opt not to send you the valuation notice is if your property has been impacted by the pandemic, you want to see it. And if it didn't change, you want to file an appeal because you're going to need to have that discussion. So anyway, you have 30 days, you file, you go to the county level, you'll get a hearing notice, date and time. All of them will probably be by phone this year. I mean, I don't anticipate that we'll all be going into the county appraiser's office and sitting down like we used to across a conference table. So you might want to talk to them beforehand when you get your hearing date and time. Say, can you send me the information that shows how my property was valued so I can see it before my hearing? And I think they will. They'll send you whatever. I've never had a county say, no, I'm not going to give it to you. So you can get that information, and that gives you a little bit of lead time to kind of look at what they did. There are 3 approaches to value for property. You can have an income approach, a sales comparison approach, or a cost approach. So when you get that information, you'll be able to see which of the approaches the county relied on. That will help you get started on what you're trying to find in your own, information to see. In the appraiser's office, you can check their website and look at the numbers. So let's say when you get your valuation notice or you look at it online, read the appeal notice clearly, because some counties are lovely and they let you just pick up the phone and call and say, I really would like to have a hearing. I want to appeal my property. And they say, great. What are you doing on February 3rd or whatever? And you get your date hearing. It's very simple. Others require you to fill out a form and send them a copy, and then and very few let you do it electronically. So read the valuation notice, find out what you need to do, be prepared, and hopefully you're in one of the counties where you can just call. You'll get let's talk about this. We call them informal hearings at the county level. Invariably, the county will ask you, what do you think your property is worth and how did you get that? What are you relying on? And they'll say, or what about our valuation is incorrect? Well, please don't fall for that. The law is quite clear. The county is the one who is to begin the discussion of how they valued the property. They should start with saying, here's the way we valued your property. Here's what we looked at. We relied on this approach to value, and listen to what they're saying. For instance, if they say we relied on the income approach and we consider your property to be a B+ investment grade and we're using $20 rents, and you're thinking to yourself, my most recent lease was $12 a square foot. Well, you tell them that. Now you know where the problem is. Now you know why your number is different than their number. And you can let them know. They will probably ask you for copies of leases, and they will probably ask you for your income and expenses. I don't really recommend turning those over unless you're comfortable understanding whether that information helps you or hurts you. Many people are very comfortable with it, and that's fine. But if some people keep, I have one client who owns a number of properties, good properties, and his income and expenses are by pencil on a piece of paper. And others are very sophisticated. Others have annual reports that come from their, audited. But, if you feel good about it, great. If you don't, then call somebody and kind of review the information and say how it would be interpreted by the county appraiser. Because the method that the counties use are slightly different than, let's say, you would use if you were buying an investment property. So know what you're looking at before you start turning over everything. The other thing is if the county tells you, we relied on a sales comparison approach, that means that the county looked at sales of what properties that they think are comparable, and they make adjustments to those properties to compare it to yours. So what adjustments they might make would include maybe adjustment for age difference, size, quality of construction, location, and that the paper that they will give you outlines every one of those adjustments from the top to the bottom. One little hint that I will tell you is at the very bottom of that sales comparison approach is a number. And it's like a comparability number. And think of it this way. If I said to you on a scale of 1 to 100, how comparable is this property, with 1 being a perfect match? Well, if all of your numbers are over 100 on the bottom line, you know that the county struggled to find properties that are comparable to yours. So you may have an argument there that they didn't use the right ones. And if you get in advance, then that gives you a chance to drive by the property and see if you can make your own comparison. If your issue is condition, then just be prepared. Maybe you get some bids for repairs if you think your roof needs to be repaired, or your parking lot needs maintenance, or there's some stigma item. In other words, something outside of your property that's impacting the value of yours. Like if you're next to the waste dump, or you're across the street from, 7 empty buildings. The computer that values your property at the county level doesn't know all that. So it helps to have the human input from your side. I tell people, don't get overly optimistic about getting a resolution at the local level. Some counties just have arbitrary limits about the amount that they will authorize an employee to make an adjustment. So don't get real excited if you get a reduction, then evaluate it again and decide whether you want to go from there to the full board of tax appeals. So we're through with the county, and now you have 30 days to make a decision. They send you a results notification. Again, read it. It'll tell you exactly what to do to appeal. Follow those to a T. And once you get to that level, you can make a decision about whether you want to go to the small claims division or you want to go to the full board. All residential go through small claims. Taxpayers can decide whether they want to skip it. If your property is commercial and it's $3 million or less, you can go there. I didn't used to recommend people, I just say avoid it at all costs if you can. It just adds time. But the Senate has recently confirmed an individual, Tom Brown, to run the hearing, and he's very competent and knows how to run a hearing. And I think you may be pleased with trying to get it resolved at that level. It's way less formal than the board, usually on the phone. But if you don't like that decision, you can then go on to the full board. The only thing I will say about the full board is it is essentially you're back to the same kinds of questions. Looking at the approaches to value, making your same arguments about condition, etc. It's just more formal. The county may hire an expert, you may hire an expert, there may be, the board can have depositions and subpoenas and all kinds of things. Most cases do not involve that much, but it's available. Now, the board, this is an interesting discussion if people are inclined to want to talk to their senators about this. There are 3 positions on the board. One must be a lawyer, one must be an appraiser, and one must be a CPA. Currently, there is only one person filling. The lawyer position is currently held by Chairman Mason. But to add more drama to that, his term has expired and he will be leaving on April 15th. which will leave us with no one. The governor has nominated 2 individuals. One is an appraiser, Robin Marks, and the other is a CPA, which is Ginger Powell. I'm not going to talk about those people. If you want to send me an email, you're more than welcome to, and I'll talk to you about what I think about filling the positions. But in any event, there's still an open slot for the attorney position. If there are any attorneys listening who would like a job, then apply at the governor's office. It pays well, even though it is a full-time job. Anyway, right at the moment, we're a little bit in flux, but as a general rule, there's 2 things that you need to know. The board must follow the law. They must apply the law as it's written, and they must apply the law as it is interpreted by the courts. So if there's a published appellate decision on an issue, BOTA is bound to apply that to the case that you have. I keep a running list of cases. If anybody's dying to have some, I'm more than happy to email the sites to you, and you can read and see if any of them apply to your particular case. But they are bound by that, and you'll get an order after your hearing. And once you have your order from the full board, it's actually after you complete your hearing, the board has 14 days to issue a summary decision. Read the paragraph again on how you appeal, because you can ask for a full and complete opinion, and BOTA has 90 days to kind of flush out their summary decision. The county can only appeal to the Court of Appeals from that decision. The taxpayer has 2 options. One is to the district court or the Court of Appeals. If you go to the district court, you start all over. It's, back to square one. You can change all your evidence, put on something new, do whatever. I mean, BOTA probably gave you a roadmap as to what you didn't have in your hearing, and now you can start all over and get your evidence in. If it's just a legal question, you go to the Court of Appeals. You can appear at BOTA with anybody representing you. It doesn't have to be an attorney. It can be a consultant, it could be a next door neighbor, it could be your CPA, a real estate agent, doesn't matter. Once you get to the district court and the Court of Appeals, though, you should retain counsel, because that's really a much more formalized legal proceeding. There is some legislation that's currently pending that would say if the taxpayer appeals to the district court, the burden is on the county. Because the burden is on the county at the Board of Tax Appeals if the property is owner occupied. It's on the county if it's an investment property and you give them 3 years of income and then the burden stays on them, and they have to carry it. And there's no presumption that their number is correct. So it's about as fair and level as a taxpayer could hope for. If the bill passes, that would be the same in the district court as it was at the Board of Tax Appeals.
Right, Linda, let's pause there. We've had a couple of questions that have come in, and we're kind of, at least as I'm listening to the conversation, at that point where it's, you get your appraisal, you can appeal to the county, the Board of Tax Appeals, and then the district court if we get there. So let's pause there for just a half a second. Answer for me, though, really quickly. How does this differ if I'm not an investor? I've just got my one residence where I live. Is the process fundamentally the same? We've had a couple of questions come in along those lines, and then one specific question that I'll throw open to you or Dave here in just a minute. But how does this process look different, if at all, for John and Jane taxpayer?
Okay, if it's a residential appeal, it's going to be pretty straightforward. The county's going to have, in most counties, they will have a wealth of information about properties that have sold around you, in your neighborhood that are comparable, and then you're just, they're 90% chance they rely on the sales comparison approach. You ask for that sheet again that I talked to you about. You can drive around your neighborhood, look at all the houses and see what the difference is. If you're on a, once again, same kind of thing. If you're on the corner and it's a busy street and they've appraised you as somebody that's on the golf course on a cul-de-sac, you've got an argument. So it's the same question, and the same thing with maintenance and improvements. I had this conversation just yesterday. If they say well, you just put a new roof on, so I'm raising the value. Then what you should say is, well, could you show me on last year's value when I didn't have a new roof where you reduced the value of my property because it had a bad roof? Because it really is irrelevant. If they value your property as if all of the improvements are acceptable or standard or up to market. And so I think that's really what that bill is trying to address, is that if you put new windows in, the value of the property shouldn't necessarily go up if it, particularly if it was, if they haven't been giving you credit for bad windows before, they shouldn't suddenly increase the value to account for that. But it's basically the same thing. And you can't, you will have to go to small claims though if you have a residential appeal. And don't forget, you can call the county anytime and argue with them. You don't have to have a hearing about it. You can talk to them before the value comes out. You can talk to them after the value comes out. Just keep, you know, and you can make offers to sell. You can say, you put my house on for $350. I think it's $325. Can we settle at $340? Whatever. You know, you can do that and see what they say. I mean, you have options and you can talk to them.
Dave, I know you had a question for Linda, so shoot.
Well, actually, she answered it. It was on one of those residential issues.
Okay, well, good. I'm glad that we're simpatico here. We've got a question that's more level setting than anything else, and it reads as follows. Rubs me the wrong way that the nicer you maintain your property, the more you're taxed. From that perspective, it is counterintuitive to be a good steward of one's property. Should property tax not be a standard rate based on another metric? Any thoughts on that one? It's about, you know, just the idea of if I want my property taxes to be lower, I'm gonna, I mean, maybe not, you know, run a slumlord type operation, but I'm not going to do some of those things that you just mentioned, Linda, by way of putting on a new roof or a new coat of paint or some of those other types of things. So does this get to that routine maintenance kind of an idea? Dave, if you want to weigh in after Linda takes a crack here because of the legislation, you're on deck.
Yeah, years ago, there were issues about environmental, you know, pollution or whatever. And for a long time, nobody wanted to talk about it. But now taxpayers will routinely say if there's some environmental issue that's impacting their property. And for a while, counties would say, but you haven't fixed it. Okay, I haven't. And you can't tell somebody that they have to make an improvement on their property if they're fine with the of New York City that said, where the judge said, you can't just look at a property and say, imagine if it was perfect. You just value what is there. And that's why I'm saying most of the time, unless the county appraiser has been out to the property and done a more detailed look at your property, they probably won't know whether you have some wood rot on your windows or your roof is at the, you know, the 14th year of a 15-year roof, etc. They probably don't know. And so they've been valuing it as if it was a quality roof all along. And so replacing it shouldn't change the value at all. Now, if you add on, or you've got your house completely renovated and you go from, you know, a 2-bedroom to a 4-bedroom and, you know, you got a bunch of bathrooms and it's a gorgeous house. Yeah, but that's not really what we're talking about. I think people just get tired of being nitpicked to death about, you know, certain things. But the bottom line is, they are required to value the property as it sits in the condition it is on the January 1 date. They can't make it any better and they can't make it any worse. So if that answers your question, that's.
Dave, any thoughts on that based on the legislative proposals that have been considered lately?
Yeah, it was interesting in the hearing on the issue of not raising valuation for routine repair and replacement. The appraisers said, well, that's the law now. We don't do that. But we heard over and over again complaints. And so what we said, well, your taxpayers don't believe that. And so Linda's, that's spot on to say, show me where we got the credit, where you reduced my value for that much last year. They can't. Asking questions is really important. I just this week had a hearing on appealing my house value And he said, well, you have upgrades. And I said, well, what upgrades? And he didn't have an answer. Somebody told them there was I don't know how they got it, but there were no upgrades. I mean, I'm in a building. These are like condos next to each other. They're all the same. I've been in them. That's what. So don't be bashful. Ask questions and play dumb. What do you mean by that? I don't know. Tell me. Show me.
Right. You know, there's one other thing too that I'll just throw out here because we don't talk about it very much. But let's say you're asking these questions and the county says, well, I'll go over the relevant facts. Your house is 3,200 square feet. And you're going, wait a minute, wait. I don't have 3,200 square feet. I have 2,200 square feet. And these mistakes do happen. The interesting thing about that is if there's a clerical error in the description of your property, now it can't be like a bunch, but if it's a mistake, you can actually file a tax grievance and go back 2 years and get refunds. So pay really close attention because I think actually the very first appeal I had ever after reappraisal, I looked at the county's cost approach and the county appraiser had an overhead door for this. It was a manufacturing plant or a distribution plant. They had an overhead door and they had the measurements as 10 feet high and 1,000 feet wide. Well, it wasn't 1,000 feet wide. And it's, lo and behold, when they fixed it, he got the value came in right at our number. And because they had made a mistake before and he hadn't picked it up, he got to file a tax grievance and got another year's refund on top of it. So look for clerical errors that will benefit you. Or mistakes. Sometimes they'll say you have 4 bathrooms. Sometimes that won't help. It's really more like a square footage error or maybe location, that kind of stuff that you can fix.
We had one more overarching question here, and then we've got several specific ones that we'll get to. Also, just very briefly, I put my email address in the chat. So if you have questions that we don't get to tonight, or you want to follow up with anybody, you can find it right there. You can also find us at kansaspolicy.org. If you haven't signed up for our newsletters, obviously you're here, so you're in touch with us in one way or another. But go there, sign up for our newsletters, learn more about this and countless other issues that KPI covers. But here's the overarching question that we'll let Linda take a first crack at, and then Dave as well. Can we expect county appraisers to fight residential appeals harder in 2021 because of the impacts to commercial properties in 2020? For instance, will they reject all appeals on their face and rely on BOTA to do their dirty work in the hopes that most people won't appeal to BOTA and that will help their odds in the game? So do you think, given what you said earlier, Linda, about, if I understood you correctly, industrial holding steady, anything tied to hospitality and that kind of stuff getting clobbered, retail, what that means long-term as well as during the pandemic. Do you have any reaction to that question about fighting residential appeals harder this year than maybe otherwise would have been fought in the past?
Yes, I think they will fight harder. It doesn't make any sense to me because I've represented a lot of counties over my career. And I tell them the sooner you can get to an answer, the better. And if you can get that value agreed upon when it goes, so it goes into the tax base at the right number and they're not appealing, that's a win. If you wait and stall and you get to the point where you have to pay a refund and it has interest on it, and you knew all along you were going to get there, that is not a win. That is a complete failure. So every county is different. Some work better with residential taxpayers than others. But that's kind of the game. Everybody's going to be different. I'm not sure I'm going to be able to judge. I think they're going to hold on to as much as they can because they're worried that they don't have the money coming in to cover expenses that they had to take over because of the pandemic. They don't want to raise your mill levy. So I believe and there's going to be county appraisers on here, and they're going to say, no, she's just making that up. But I believe that there will be pressure applied from county commissioners on county appraisers to push the value as hard as you can so that they can hold the mill levy down, even if they fight everything, even if they know they're going to have to give the money back, they're hoping to give it back in a better year than 2021. So I'm sure everybody's going to send me an email later saying that is not true, but that's my sense. My sense is that they're going to fight like crazy. And because they don't want to raise the mill levy, which goes back to what Dave was saying in this Truth in Taxation. You know, if they double your value and hold the mill levy the same, you still are paying more in taxes. So it's kind of a three-legged stool. It's the tax base and the mill levy, and then, you know, what you actually end up paying. And I will say this too, for my commercial taxpayers out there listening, the example I always give to people is if the county, let's say the county says, I need $1. I need $1 more. Well, we assess, remember I told you commercial property is assessed at 25% of the value. Residential is at 11.5. So if I said, let's say the county says I need $100, and I give you a jar of dimes, which is sort of representing the 11.5%, and I give you a jar of quarters, which represents the 25%, you're probably going to dig into the quarters because you're going to get to that $100 faster than sitting there counting that little dime. So when Johnson County made the effort to against retail, there's a specific reason, because they're assessed at 25%. You pick up $350 million in the district value by 157 cents. That's what would you have to have done to residential to get the same result? A lot harder work. So that's me. I'm jaded. I admit it. I mean, that's what I feel like it's going to be a rough year for taxpayers. For a number of reasons, not only because it's just a rough year, but it's going to be a rough year to win.
Right. Dave, what do you think on that same topic about fighting the appeals and the valuations harder given the bumpiness of 2020?
Well, I think history certainly would support Linda's belief that they're going to fight, because we went back as part of our research for the legislation. We did an open records request for the Board of Tax Appeals and looked. I think it was like 5.5 years from 2014 to 2019, and what we found was astonishing. 71% of all the appeals that were filed that went to BOTA were found partially or entirely in favor of the taxpayer. 71%, that's an enormous turnover rate. Now, to be fair, some of those were what's called stipulated. And what we explained, that a lot of taxpayers have told us, especially the commercial taxpayers, that it's a game that some of the county appraisers will play. They'll fight you right up until it's time to go to court, and they know they're going to lose, and they don't want that on their record. So they'll agree to settle for what you want, or something, in the middle or something, right before, after the taxpayer has spent a lot of money on getting estimates, getting appraisals, hiring attorneys, and so forth. So history says, yeah, that's just what they do. And that's part of the frustration that taxpayers have expressed for years.
Okay, Linda, 3 rapid fire questions for you. We'll try to get them punched out here quickly. It seems that they're hopefully things that are answerable very, very succinctly. Can we go over the comparison number in the bottom of the report again? 100 is a comparable score, and anything over 100 is higher valued comparison, and lower than 100 is a lower valued comparison.
The number 1 is an exact duplicate of your property. That never happens, but that's the goal. 100 is lousy. I mean, that means you're so far away from 1 that they've made so many adjustments to that. It's a sale. They made so many adjustments to the sale that it makes the comparability questionable. So the sales comparable sheet that they give you, and this is for residential and for commercial, will have probably 4 to 5 comparables in there. They kind of line them up, you know, row by row. They'll tell you the property, the address, the neighborhood, the sale price, the square footage, all the stuff, and then they'll make these adjustments. But that bottom line number is the comparability, what the computer says. Well, that's how comparable the computer thinks it is. I've seen numbers of 200. That's not good. I mean, that's just fantasy land.
Okay. All right. And then what kind of proof do you need in small claims court?
Okay. Small claims, you can exchange it ahead of time. The board doesn't keep any of the evidence after you've tried your case. It's, you know, they make a decision real quick and you get it. You can bring anything you want. I love photographs. If you've got photos of the surrounding neighborhood, anything on your property, if you have deferred maintenance and you've gone and you've already determined that a new roof is going to cost, you know, 30 grand, parking lot repairs, driveways, leaky basements, all those things. If you could just call and ask somebody to give you a bid. Now, if you don't want to do that because you feel bad because you're not going to replace it or fix it right away, then, you know, just do the best you can. Just get some general information about what it costs. That's the kind of stuff that the small claims person can look at and say, you know, you didn't consider that. You didn't tell me that she was in a floodplain. You didn't tell me that, you know, her basement is caving in or whatever. So, and photos, I mean, you can talk about everything. If you have a photograph, it's something they can visually, tangibly see. It's better.
Does the county get to decide if they will value based on income, cost, or selling price?
Yes. And just because a property's sold, don't forget this, just because a property's sold doesn't mean that's what it's worth in fee simple. If it's a completely, like, let me just give you a real quick example. If you've got a property that's leased to CVS with 30 years remaining on the lease, what that person is buying is not the CVS building. They're buying the right to receive income from CVS for 30 years. So, and you would pay a different amount if you were 2 years left on the lease, or if there are 5 years left on the lease. So a sale of an investment property will tell you what investment properties sell for. So, but if it's a sale of a residential property, that's good. I mean, a residential property is not leased. It doesn't have any really investment value. If you can see that you show that you purchased it, or, you know, what you paid for it. And, you know, also if it's residential and you bought some other stuff like a barn or a tractor or a riding lawnmower or whatever, the drapes, you name it. If you put that in the contract and itemize it out, then that'll help them make some decisions about removing the value of personal property.
And then as far as appealing, if I get my property appraised and it's on cost, do I have to, when I go to appeal, do I have to appeal it on cost grounds? Or can I appeal on income or selling or?
Any way you want to do it is fine. If you hire an appraiser, what they do is generally they attempt to do all three approaches and reconcile. Sometimes they'll say, I didn't do a cost approach because it would not get me an answer that's reliable. And so they'll do two. But you can talk about whatever you want to talk about. You do not have to rely on the cost approach. And I'll give anybody $25 if you can tell me that you can look at the county's cost approach and come heads or tails of that information. It's just designed to be confusing. Nobody understands it.
Okay. And then is there anything to prevent, I'm paraphrasing here as a longer question, anything to prevent the county from, if I'm understanding the question correctly, kind of overvaluing compared to comps every year and then going through the process and, you know, let's say my property should go up roughly 4%. They increase it 15 every single year, and then we end up appealing and it goes up 8, but then the next year they just come back and say 14% again, and then we have to start the whole dance over again.
We used to have this great law in Kansas. It was 79-1460, and it said if you got a reduction as a result of a valuation appeal, they were required to carry the value over to the next year, saving people from this constant argument that the legislators kept getting. I appeal, I win, they come right back at me the next year. I appeal, I win, they come right back at me. Then Johnson County, then the legislature said, what if we made it 3 years, roll it forward 3 years? And so I think it was 2 initially. So, but somehow they settled on extending that rollover period. And then Johnson County, even though this had been the law for, you know, a couple of decades, they decided suddenly that when it got to be one more year longer, that they had to roll it over, that suddenly it was unconstitutional. So they filed a mandamus action and got a bunch of other counties to join in, and the Supreme Court threw it out. So we had positive, helpful legislation for a while, but counties didn't like the fact that they had to roll it over. I mean, it's the truth of the matter is, if you talk to your legislator, why don't you talk to them about reappraising every other year? I mean, I keep telling people get really mad when that tax bill comes out every year, and they get really angry when the valuation notice comes out. If you do it every other year, they'll get angry at you every other year. I mean, this is a good thing, and it would loosen the thing on the courts. You'd only have to appeal once for 2 years. Allegedly, the county would have time to get better data, make better decisions, but no, we still do it every year. And the number of states that do it every year is lessening as time goes on because it's expensive. It's crazy. I mean, value doesn't change much on a residence from one year to the next.
We've got a couple questions here about ag and farmland, and they both circle around the idea of ag land with a residence on it. Or let me see here, where the ag land is rented out, but I'm still living on it and not actually doing the farming or myself. Do you have any thoughts on?
That's fine.
Okay.
It can still be agricultural use valued, which is beneficial. I'll just tell you, it's the agricultural use value is a fraction of what its market value is because of the way the formula is set up. But so you can farm it yourself, or you can lease it out and have somebody else farm it. If you do put it on paper, it's because the county is going to want to see the actual lease, so they know that you're doing that. They carve out the area where the residence is, and they value it as a rural residential property, so that's not use valued. And the other thing I think you should say is that when you get to the Board of Tax Appeals, if your argument is about agricultural use value, which I can't imagine why anybody would, because it's like 1/4 of 1% of what it's worth, then the state comes in and defends the value. But just on the ag land, the house is just going to be treated as a rural residential property. So there's some advantages, though. You might want to look at some stuff and see if the county is valued. Let's say the barn is part of the operation of the farm, or it's a class B, it's really a C, that you're not going to win. But if they have your square footage wrong, the number of floors wrong, the number of bedrooms, the fireplaces, then you file what we call a tax grievance. And if you're good about statutes, it's 79-1701, and then 2 and 3 and 4. It shows you exactly, you can get the current year plus 2 years.
Okay. And then one last question, and as I'm winding up to this and giving Linda a chance to pause for a moment, we didn't get to everybody's questions here, and we're going to try to get done in about an hour. So Dave and I have both put our email addresses in the chat box over there. Send us an email tomorrow, and we'll get you in touch with Linda. We'll answer the questions as best we can as well. So Linda, here is the, if you just give me the thumbs up, I can enter your email address into that in chat box as well. So I'll do that while you're answering this next question. And here it is. And then Dave, you're on deck for a parting shot. So here's your last question, Linda. When I questioned the valuation of our commercial property, the county said they used a, quote, economic condition factor for our town. And that's not negotiable, apparently. Also, I was told by the county appraiser the dark store theory is based off a situation of hypothetical lease fee. We cannot base any of our valuations off of hypothetical, whether it is commercial or residential. She also told me she's using a theoretical lease fee. She said I should be able to lease my building for $9 a square foot, and she got that from some state book. So how respond?
Okay, well,
there's a lot in there, and you've got about 3 minutes to
Okay, counties use a hypothetical lease fee. They don't understand what fee simple is. So they say you can't value property in hypothetical lease fee, and I agree. The law is very clear. It's fee simple, period. There is no dark store theory that any taxpayer has ever advanced. It's just a big PR stunt in order to try and tax the value, the intangible value of a lease. And they, so, I mean, I'm happy to, if, you know, he's going to put my email up there. I'll send you some articles. In Kansas, the law is clear. You have to value the property as if it is vacant and available. Now, that does not mean boarded up and deplorable. It just means it's the same beautiful building that we're looking at, but we're just saying it's vacant and available. In other words, not already leased, but to be leased. So then you get to take into account leasing fees and costs, commissions, the length of time you think it would take to get your building occupied, and any tenant improvements that you're going to have to make in order to attract the tenant. That is solid, generally accepted appraisal practice to get you to fee simple. So if somebody says hypothetical lease fee, let me just tell you that the testimony in the Walmart case that I tried, the county's expert said, I'm valuing this property as if it is leased to Walmart with at least 20 years left on the lease. That is a hypothetical lease fee. Because next year, what are they going to do? Well, you know what? Shockingly, they're going to value the property as if it's Walmart and it has a 20-year remaining lease. And 10 years down the road, it's going to be Walmart, still 20 years left on the lease. So none of that is the right way to do it. It's just not, you know, I love that commercial where the woman says, none of this is the way you do it. That's right. None of that is the way you do it. But when you do what they say, I don't know what they call it, but anyway, if you use their method, it results in valuing the intangible business value attributable to the, and none of those had anything to do with the value of the fee simple. So I don't know who your county appraiser is. You know, I'm sure I've argued against her already, but that's the law. If the county wants to change the law, which they're trying to do, because they have the case on appeal, and they've said that's what they want to do. The truth is they should be in front of the legislature and see if they can get it changed. I will tell you my opinion, and I'm not a constitutional law scholar, because I think the only way you become that is if you say you are. And I'm not willing to say that, but I'm pretty sure you have to change the Constitution if you're going to tax commercial property and pick up their intangible value, because the law says we only tax tangible value. Now I forgot what the other part was, the question, but see, I get that's my favorite subject matter, next to highest and best use, which tells you how exciting my life is. What was the rest of her question? That was good.
No, that's fine. You did good. I just got to thank you. I just got to thank you from the person who asked the question, so we're good. And speaking of constitutional legal scholars, I do it than just saying that you are, but it just so happens that our partner organization, the Kansas Justice Institute, does litigate not tax questions, but constitutional questions at the state and federal level here in Kansas. We've been involved with COVID cases about the Fourth Amendment, speech cases related to raw milk of all things and the sales of that perfectly legal product. So check that out at kansasjusticeinstitute.org. SentinelKS.org is our media outlet where we cover these issues at the county level, what's going on in Topeka, and generally try to hold government and media accountable as well. And then, of course, kansaspolicy.org is our policy shop and the online home of Kansas Policy Institute. And you can also find all these groups at all the usual online watering holes, Twitter, Facebook, and Instagram, and all the other great social media places that I try to avoid like the plague. So again, we're going to go Dave first and then Linda with parting shots here. If we didn't get to your question, like I said, I put my email, Dave's email, and Linda's in that chat box. Send us an email tonight or tomorrow, and we'll get the best answer we can back to you. As well as, you know, if you want to get signed up for something, just reach out to me directly and we'll get you plugged in wherever the place is. Dave Trobert, CEO of KPI, you've got a minute and I'll cut you off at a minute and a half.
And he's not kidding. Thanks, James. I want to start by thanking Linda for not just for being here for tonight, but for being a tremendous help to the group of folks who were working on property tax reform over the last few years, it was invaluable to have the advice of a tax attorney you could trust, who have been representing taxpayers. I also want to thank the participants here tonight for taking some time out and learning. Hopefully you found good value in this. And finally, I want to thank our donors because none of this is possible without the hundreds of people in Kansas who support our nonprofit work. Watch your email tomorrow. You signed up for this, so we have your email. Watch your email inbox tomorrow, or maybe Monday, I guess. We'll get a link to the recording for you to share. We'll also provide links to some of the petitions that we have out about property tax reform. And finally, don't hesitate to communicate with your legislators. Regardless of whether you're for or against something, make sure you let them know. It's terrible how few people really communicate with legislators, and a lot of them say, if you can get them to talk to us, we'd love to hear it. So thanks again for being here, and I'll kick it back over to James.
All right. Thank you, Dave. And there's always a couple of people who make sure that I don't break anything when we do this. Hannah Nelson on our staff, Ellen Hathaway do work in getting the word out for you all to join us, and then make sure that I'm halfway competent in navigating the WebEx portal as well. So thank you to Hannah and Ellen, and frankly, the rest of our team, but those two especially for tonight. So Linda, again, thank you very much on behalf of KPI and everybody who joined us tonight. And as Dave said, all of our supporters around the state. And a parting shots from you.
Oh, no parting shots. Just, I gave my email, and I talk about this subject all the time. And I tell people, feel free to email me. I mean, I may email you back and say, I'm in the middle of a trial and I'll get to you as soon as I can. But, free legal advice is sometimes slower than non-free legal advice. So, but anyway, I'm more than happy to answer any question, and I frequently do. And I'm even happy to answer them if my answer is you're better off doing this by yourself, because they'll be more sympathetic than having me come on your behalf. So please feel free. I promise you I'll try to get to it as fast as I can.
All right. Well, thank you, Linda. Thank you, Dave. Thank you for all of you for joining us. Surprised we didn't have any questions about what happens to property values with cracked water pipes or anything like that. But I hope everybody stayed warm and safe. Have a good Friday and a good weekend. Take care.